Imagine you are told your job is ending, and you are faced with a whirlwind of questions. One of the most important distinctions you will need to understand right away is whether you have been laid off or fired, because these two terms, though both mean separation from employment, trigger very different sets of employee rights and protections. The core difference in employee rights between a layoff and a firing lies in the reason for your separation from the company. A layoff is typically a company-initiated decision, often driven by business needs like economic downturns, restructuring, or the elimination of a position, and it is usually not a reflection of your individual performance. Conversely, a firing or termination for cause happens when an employer ends your employment due to reasons related to your individual performance, conduct, or a violation of company policy. This fundamental distinction impacts everything from your eligibility for unemployment benefits to potential severance and even your ability to be rehired. When you are laid off, because the separation is not your fault, you are typically eligible for unemployment benefits. Many companies also offer severance packages during layoffs as a gesture of goodwill or in exchange for releases of claims. Furthermore, depending on the size of your employer and the number of employees affected, a layoff might trigger protections under the Worker Adjustment and Retraining Notification Act, also known as the WARN Act, which requires employers to provide 60 days advance notice for certain mass layoffs or plant closings. On the other hand, if you are fired for cause, your eligibility for unemployment benefits can be challenged or denied, and you are generally not entitled to a severance package unless you have a specific employment contract that says otherwise. If you are in an at-will employment state and are fired without cause, you may still be eligible for unemployment benefits, but typically not severance. To understand your specific situation, it is crucial to ask your employer for a clear, written reason for your separation. Review your employment contract, if you have one, and your company's employee handbook for any stated policies on layoffs or terminations. Immediately contact your state's unemployment office to understand the application process and your eligibility. If you believe your firing was wrongful or discriminatory, or if you have questions about a severance agreement, consulting with an employment attorney can help clarify your rights and options. One insider detail to remember is the distinction between a for-cause firing and an at-will termination. While being fired for cause implies a specific performance-related reason, many employees are at-will, meaning their employment can be ended by either the employee or the employer at any time for almost any reason, as long as it is not an illegal one, such as discrimination. Understanding if your state is an at-will state is very important for knowing your baseline rights. Also, for layoffs, keep in mind the WARN Act requires certain employers to provide a 60-day notice before a mass layoff, giving affected employees time to prepare. Ultimately, the crucial takeaway is that the reason for your job ending directly dictates your rights and benefits. Whether it is a layoff due to business conditions or a firing for individual reasons, gaining immediate clarity on the specific cause of your separation is the first and most important step to understanding your entitlements, assessing your options, and protecting your financial and professional future.